The hearing will start now. This is originating application 881 of 2023, summons 3500 of 2023, Babel Holding Limited.
Yes, good afternoon, Mr. Chan, Ms. Lee, and Mr. Xu for the applicant, correct?
For the applicant, this is their application.
Sorry, I mean for the judicial manager, sorry. Yes. Yes, all right, thank you. And all right, Mr. Chu Hoi, Mr. Mark Tan for Parastate Labs.
That is right. Good afternoon, y'all.
Good afternoon, all right. Other parties as indicated to my manager. Let me just administer the Zoom allocution. So parties reminded that there is to be no unauthorized photography or recording in any form and no dissemination of any photographs or recording of these proceedings. And only those counsel or persons notified to the court should be present at each location, and parties should treat these proceedings as they would a physical hearing. All right, Mr. Chu, it's your application for a stay, I believe.
That is correct, Your Honor.
Yes, all right.
Your Honor, if I may, Your Honor, we have filed an appeal in CA 33 against the grant of the scheme convening order.
Yes.
Your Honor, our position on appeal is that the explanatory statements and the information provided does not actually make a fair presentation of the assets of the companies for the creditors to be able to vote on the proposed scheme. I think, Your Honor, we've pointed out that the companies had raised about 125 million from January 2021 to May 2022. The last round of fundraising came to about 80 million, and that happened in May 2022. The financial statements produced so far do not explain where this substantial sum of money has gone to. I think Holohan Loki did not actually look at this sum of money in their analysis of the liquidation scenario. Your Honor, our point is that our concerns are antecedent to the question of whether the merits of the proposed scheme are fair. I think our position is that without the asset information of the companies, creditors cannot even start to consider the merits. So in essence, Your Honor, we say that there is insufficient disclosure. And of course, Your Honor, we understand Your Honor's decision, but we'll try to persuade the CA that there is some need for a fairer presentation of the information.
All right. What timelines do you have for the appeal, please?
Your Honor, currently the Court of Appeal has indicated that January, I think the second week or the third week might be the earliest that the CA can hear parties on the appeal. And in fact, after having Your Honor's GD last week, we have just filed and served our appellant's case about 10 minutes ago. Ultimately, Your Honor, we are saying that a stay or rescheduling of the scheme meeting should be granted so that creditors have a fair chance at having the information that they need before they can vote. I think ultimately it's about information asymmetry between the company and the creditors. I hear my learned friend's point about letting the meeting go ahead. And if there's overwhelming support, then there's nothing wrong with the process. I think, Your Honor, our point is a principled approach needs to be taken. Because if the outcome of the meeting is pursuant to a tainted process, i.e. creditors are voting blindly, I don't think we can actually say, therefore the process is okay. And it is not right to say that if creditors vote in favor of the scheme with the information provided as it is, then there is sufficient disclosure. I don't think those two things come together. And ultimately, Your Honor, I mean, my client is a minority creditor. And given that creditors are being asked to give up substantial rights, I think we should be given a chance to ascertain where the assets, which are substantial, Your Honor, has gone just before the insolvency of Babel, the Babel Group. So I would say, Your Honor, it's only maybe about a 1-2 months delay. There is no hurry to shepherd the creditors into the vote. If the creditors are given the information that we say they should be given, the outcome of
What,
any.
what is the prejudice with letting the meeting go through, say, perhaps without being sanctioned, without being granted final sanction?
Well, I think, first of all, Your Honor, we would say that there's going to be quite a bit of cost that's going to be thrown away if the meeting goes ahead and it is found that the meeting had gone ahead without creditors having a fair presentation of the information. And ultimately, Your Honor, the company is insolvent. The assets of the company actually belongs to the creditors, not the company itself. I hear my learned friend about, well, there's really substantial cost being thrown away because of the process. But in an insolvent company like this, Your Honor, every cent counts to creditors. And we
What prejudice to your client? Could I ask that? What happened? What specific prejudice is there to your client if the meeting is held in the meantime on the supposition that no sanction will be given in pending the appeal?
I would say this, Your Honor. We filed an appeal, and if the meeting goes ahead, and the creditors then vote in a certain way, without having seen whatever documents we're asking the company to produce, I think in a sense it might, Your Honor, affect the perception of the Court of Appeal with regards to my client's appeal, Your Honor, merits on the appeal.
In what way? Sorry, could you be specific?
I think when the creditors have voted in a certain way, without certain information, I think it might be a bit more difficult for my client to persuade the court that the meeting shouldn't have been carried out in the absence of those documents, Your Honor.
Well, if you're correct in principle, I don't think the Court of Appeal will be swayed by an improper meeting, as you said. Any other prejudice?
Well, I mean, Your Honor, we are basically just making the point that there's going to be unrecoverable costs, not just to my client, I mean, of course, to all the creditors as well. I think that's as far as I can push the point about why the meeting should be rescheduled until after the CA can look at this. I mean, I see the timetable that after the meeting, there's going to be a sanction application. More money is going to be thrown, Your Honor, into the application. And assuming that the Court of Appeal hears the appeal in January and agrees with my client, then it's not just the cost of the meeting itself that's going to be thrown away. It's also going to be the application itself of the sanction. And depending on when the sanction hearing comes before Your Honor, I'm not sure whether or not the CA would have made a decision by then. And we are caught in a difficult position where Your Honor decides or has to decide on the sanction. And then at the same time, there's a question about whether or not the information provided to the creditors for the vote is even fair. So on that basis, Your Honor, effectively, we are going to be spending a lot of money shepherding the creditors through a meeting, which potentially may all be wasted, Your Honor. I think that's...
Right. And how would the appeal be rendered nugatory?
Well, I see my learned friend's concession that if a sanction hearing goes ahead, they are prepared to undertake not to lodge the sanction order until the appeal is heard. And I would say on that basis, the risk of the appeal being nugatory would be, in a sense, mitigated. I mean, I see that concession from my learned friend, so I wouldn't actually say that it would be rendered nugatory, but still, the point about unrecoverable costs and the fact that I would say more information needs to be provided. Well, I suppose will support my point, Your Honor, that perhaps just a short delay to the scheme meeting wouldn't actually cause prejudice to the company, and in fact might benefit the creditors. And I would say, if we are right, then all the creditors benefit from more information as to the whereabouts of the 80 million or 125 million raised by Babel. That's not addressed anywhere Your Honor, in the explanatory statement.
All right. All right then. Anything else, Mr. Chu?
Your Honor, that's about it. I wouldn't push the point further than.
All right, thank you. Mr. Chan, was it?
Yeah, yes, Your Honor. So just to be clear, no timings have been set yet because the Court of Appeal, the registry made clear that they're not going to set timings until this stay application has been determined. They did say prior to that there was possibly a hearing date in January or maybe in February, but nothing has been fixed as of now. And the point really is this. The first point, if this is an application for a stay pending appeal, currently there is no appeal. My learned friend filed his appeal on the last day of the 28 days, that is on the 6th of October, and he served the application on the 7th out of time. It's clear in my submissions, Your Honor, and case law that there is no pending appeal. So in effect, there's no pending appeal. The court is now faced with a situation where there are no grounds or there's no appeal for which the application or the basis the application disappears. Number two, there are two factors which my learned friend relies upon as special circumstances or nuggets or possibility to render nugatory. One, that the Court of Appeal could take a different view. But Your Honor, that's not a special circumstance. Any appeal, the Court of Appeal can take a different view. Number two, Your Honor, he says they're wasted costs. If that's the case, Your Honor, if that is a special circumstance, every single time you appeal the convening of a meeting, you must stay. Your Honor, the two grounds which my learned friend rely upon are not principal grounds because they are the very essence of the very order which you order to call the meeting, and there's a possibility of a reverse. Therefore, no special grounds. Number three, Your Honor, we have come in and offered to expedite the particular matters so that we could take timings. My learned friends delayed it. Number one, they filed their application on the last day. In their affidavit, they do not explain the reasons for the delays. In their written submissions, Your Honor, they purport to give evidence from the bar as to the reasons for the delay. They say, oh, because we've got limited resources of all the costs. Your Honor, none of this is in affidavit, which my learned friend files. All evidence from the bar to cause the delay. So the reasons for the delays are not explained on affidavit. They filed late, and then they said, then the stay application also they filed late. They say, oh, because they want to talk to us. But we told them on the 8th, we are not adjourning the meeting. They filed the application then on the 14th, further delay. And all the delays upon delays and delays, they said, look, we need to expedite. And in reality, it says, where is the special circumstance? How is it rendered nugatory? We were prepared to offer to them that, look, we won't file the sanction order if, provided, of course, the hearings take place. Provided it's been disposed, I suppose, by the 1st of March. We can't hope to keep it open right through. And in fact, Your Honor, the prejudice is the other way around. The prejudice is the other way around because we got burn rate. We set out an affidavit of expenses. Holihan's fees are 50,000 on a monthly retainer, and then on the top of that, Your Honor, we have every single month. So we have done our mathematics. So what we were prepared to offer to them a concession that we will not file any sanction order before the 1st of March or the disposal, whichever is earlier. He turns around and says, oh, therefore we admit that that might be the case. But in reality, Your Honor, we have been trying to help. In short, Your Honor, number one, no appeal before this court. Number two, what special circumstances? That it could be reversed on appeal or you incur costs. That means every single time, that special circumstance. Those are ordinary circumstances. Number three, Your Honor, it's not nugatory. Number four, Your Honor, they delay this and they don't explain the delay and now asking the court, please give me this opportunity. Finally, Your Honor, one of the considerations is on merits. By para one of, they're trying to repeat some of the other points, but Your Honor, these particular points, Your Honor, had held in para one of your grounds as no merits. And Your Honor, this point about disclosure, which I now say, is a later date issue. They're trying to conflate the test for disclosure at the leave stage where all necessary information, this sufficient information decide later. Otherwise, what actually happens is at the leave stage, the court will have to scrutinize to see whether you got a full and perfect information. The scheme jurisdiction does not and cannot work like this. In short, Your Honor, this is a case where there's simply no basis for the stay. In fact, no jurisdiction possibly, no, because no appeal, no special circumstances, not nugatory, merits, Your Honor has held no merits, cause of delay unexplained, delay upon delay. Now we've, in fact, notwithstanding all of this, offered to say if this hearing is disposed by the 1st of March, then that's fine. If not, until then, we undertake not to file the sanction. All of which, Your Honor, for scheme jurisdiction, trying to be an international debt restructuring center, this is really not a case for intervention. The meetings must proceed. We will honor and we are prepared to confirm that we are prepared to hold the sanction order if so granted until the 1st of March or the disposal of the appeal, whichever is earlier.
All right, could you remind me the timelines you are proposing to act under, Mr. Chan? The scheme meeting is to be held, if I don't
Scheme meeting is
do anything.
held on 17th of December, Your Honor. And then we were looking to file the what they call scheme application thereafter, hoping for a date in January. If not, I mean, depending on court calendar, possibly February. But the reality is this. This is the case, Your Honor. Every month we are burning money. Number two, how to get new investors when, end of the day, what if their timing is correct by the time the court decides, maybe January or maybe by March. And then after that, what? Then we come back for the whole meeting, then sanction. It's another 3-4 months after that, Your Honor. Their time frame does not work. We are concerned about monies, and the time frame we are proposing essentially is that we will hold a meeting on the 17th. We will try to get the date in January, but if the court has no date for the sanction hearing, then possibly February. But we will not file the the sanction order until the CA decides the appeal, if the appeal is allowed to proceed. Notwithstanding, they're out of time. So those are the timings we propose, Your Honor. And to me, there's therefore no prejudice, no special circumstances. Really, no. In fact, the application should be dismissed, and we will give the confirmation, and we will try to get as early a date as possible for the appeal, if allowed to proceed.
All right, thank you. All right, back to you, Mr. Chu.
Yes, Your Honor. Just a couple of matters. I think, first of all, my learned friend makes the point that, well, the information to be provided is to be provided by the sanction stage. Your Honor, they have already issued a notice of meeting on the basis of explanatory note or statement that was annexed to their 881 application. So that, Your Honor, forms the basis of what the creditors are to look at the meeting itself. My learned friend has indeed indicated that they are prepared to issue a supplemental explanatory statement, I believe on the 9th of December. We don't know what the contents are. They say it will address my client's concerns about, well, effectively where the money went. But we've not seen that, Your Honor. It might well be, Your Honor, that whatever that is issued is still not sufficient. So my point really is that it's only going to be a short adjustment of the timetable. We are not asking for this meeting to be held in abeyance until such time as there's no determinate time. We're not asking for that, Your Honor. We're just asking for a chance for the meeting to be pushed back, for the CA to look at whether or not the information is fair to the creditors. And if it turns out, Your Honor, that the meeting is unfair, then this whole set of costs will have been wasted. I think my learned friend says there's no special circumstances here because every appeal there will be wasted costs. I think the factual situation here is quite different. The money that they are wasting, if the meeting is improperly held, is money belonging to creditors. It is not money belonging to the company. So that's the distinguishing factor here, Your Honor. And when my learned friend says there is prejudice to the company, I think the truth of the matter is that if creditors are forced to go into a vote on the basis of insufficient information, it's the creditors who are prejudiced. And if it turns out that the meeting is improperly held, the creditors will be doubly prejudiced by that, Your Honor. So
Mr. Chan says you don't have an appeal in yet. How do you respond to that?
well, Your Honor, that's really quite unfortunate, Your Honor. What happened was we filed an appeal on the 6th of January at 11 a.m., Your Honor. We marked urgent handling. Sometime about 3 p.m. that day, we wrote to my learned friend, informing them about the appeal. and then trying to fix an expedited timeline for the appeal. Well, I suppose as it turned out, the appeal papers was actually approved by the court only on the 7th of January. And based on the automatic service, it was actually served on my learned friend at 9 a.m. thereabouts on the 7th of November. I'm so sorry. So the effect, Your Honor, is there's a 9 hours delay. My learned friend takes the point that, well, that means in effect there is no effective appeal, which is why we filed an extension of time application. The appeal delay is de minimis, Your Honor.
And what is the status of your EOT application?
Well, I think the EOT application is again pending, Your Honor, today's hearing. The CA has not given any directions on that, subject to what happens today, Your Honor. But I would say, based on the principles of case law that I've seen, it does appear that if it's a de minimis delay, an extension of time of 1 day will usually be granted.
You say it would be likely to be granted?
Yes, Your Honor.
All right,
And-
so at the end of the day, your prejudice or the impact of the appeal, or rather the meeting we'd like to go through, is really in terms of the effort and costs of that might be for naught if the appeal is heard, correct?
That is right, Your Honor. And hearing from my learned friend, it looks like once the meeting is, well, I suppose proceeded with, there'll be further costs that they will incur by filing the application for sanction. Still going to be costs that potentially is not going to be recoverable, Your Honor.
I was under the impression that there were that the timelines would be expedited, but there seems to be a bit of uncertainty about what timelines, if any, are in place. Mr. Chiu, what's
Yes.
the position?
Your Honor, we've got a letter from the CA indicating that the available dates are 15th of January to the 26th of January, or the 19th of February to the 1st of March. We understand, Your Honor, that court vacation will be coming, which is why when we filed an application for expedited appeal, we also entered in discussions with my learned friend about timings. I think Your Honor will have received a letter from my learned friend asking Your Honor to deliver the GD by the 24th of November. That, Your Honor, arose from discussions with my learned friend. And in fact, when we first filed the notice of appeal, we wrote to my learned friend to suggest doing away with the GD, taking very expedited timelines for my clients to file their AC, giving as much time to my learned friend as possible to file their respondent's case, and then having the appeal heard as soon as possible. But as it turns out, parties couldn't agree on the timing, and we ran right smack into court vacation. So that's why, Your Honor, we are in this state where we had to take up the stay application.
All right, but if I were to grant you a stay, what are the next steps in terms of the expedited hearing?
Well, Your Honor, we filed the appellant's case just a moment ago. I think my learned friend will be filing their respondent's case. If I could just check, based on parties' discussions. I think sometime at the end of 29th of December. And then the appeal, if it's fixed for the second week of January, we will have some kind of certainty as to where the parties are. So, well, Your Honor, effectively, the time that we're really asking for is not that long.
Sorry, Your Honor, I know my.
Hold on a moment, hold on. Let me hear whether Mr. Chiu is finished. Mr. Chiu,
I'm done, Your Honor.
all right. Mr. Chan, yes, last word to Mr. Chiu.
Your Honor, essentially no time frames have been set by the Court of Appeal. These particular dates which was given earlier in terms of a possible date for the particular appeal, but that has all been overtaken by the stay application and the EOT application. So those particular timings may or may not still be available. So first point is that there's no timelines. Number two, Your Honor, my learned friend says wasted costs, but my point or proposition is really this, because every time court gives directions, you file an appeal, there's going to be wasted costs unless you stay. If that were the case, then they make their case automatically. That cannot be right, Your Honor. My clients have settled on affidavit. We continue to incur a lot of expenses. The meeting is going to be held in just over 2 weeks' time. And, you know, to call off a meeting so late into the particular day, I think is wrong. And where there are no special circumstances, it's not nugatory, there's really no grounds to intervene. We have already said that we will not file before the first, and the timelines that the court of appeal had indicated is that you should be able to get date by the 1st of March. And number two, Your Honor, is that in the meantime, we proceed. We don't lose money. What my learned friend says, never mind, you continue to burn the money. You just save the cost of the hearing and convene the meeting, but you spend all the administrative expenses, etc. That US cases, Your Honor, shows that when you're looking at a stay, your administrative costs, your running costs all come into play. My learned friend focus on one set of costs, and we are saying that the other sets of costs to keep the business running. Your Honor, it comes back to this point. There's no appeal, no special circumstances, no nugatory. We have been prepared to confirm the 1st of March or earlier disposal of the appeal. And Your Honor, the timeline should be allowed to proceed. Particularly since we have no timelines by the court appeal now.
No, Mr. Chan, you keep saying there's no appeal, but a 1-day delay is not going to lead to a dismissal of the appeal for lateness. I don't see anything like that in any of the CA decisions or AD decisions.
Your Honor, I mean, but even that, Your Honor, there are no grounds. I think our position is that these are not special circumstances, because special circumstances is the very subject matter of your convening. Because if that is the case, every time you appeal a convening meeting, to save costs, because it could be reversed on appeal, and therefore that's special. That, Your Honor, cannot be the case, because it means then we will never be able to have any convening meeting until the Court of Appeal decides. Scheme proceedings must proceed expeditiously. All the more so, Your Honor, in this particular case, we said that we will file an affidavit to actually, supplemental explanatory statement to explain the whereabouts of the particular money. He's very concerned. And also, Your Honor, if this were correct, every time you convene a meeting and then they come out explanatory statement, you say this is not satisfactory, please now court decide sufficiency. Sufficiency, fairness is later. Your Honor, my submission, there's no ground to intervene. We will in good faith work to expedite the appeals.
All right. Last word to you, Mr. Chew. Anything else?
No, Your Honor. I mean, I'm in your Honor's hands.
All right. All right, let me just stand up for about 15 minutes or so to collect my thoughts, and I'll give my decision accordingly. Stand down. Thank you.
Your Honor.
Court is adjourned. The hearing will resume now.
Your Honor, may I just briefly say that my colleague, Ms. Alexander Yu, who just came from another hearing, has just joined us.
All right, thank you, Mr. Chan. Thank you. All right, I will now give my decision. Given the nature of scheme proceedings, despite the best efforts of Mr. Chew, I'm not persuaded to stay the convening of the scheme meeting. I will allow the scheme meeting to proceed. The costs and resources expended for the running of the meeting will indeed be for naught if the appeal succeeds. But on the other hand, holding off the meeting will also incur other costs contributing to the burn of the assets of the company. Furthermore, it is of the very nature of scheme applications that costs and resources would have to be consumed. I do not think, therefore, that wasted costs would be reason enough to stay the scheme meeting pending the pursuit of any appeal. These costs do not rise to the level of rendering an appeal nugatory, nor are these special circumstances. It will be premature for me to rule whether any court approval of scheme should be granted following the scheme meeting. The existence of a pending appeal or any pending appeal would probably be a relevant consideration at that time. I thus make no order now as to whether any approval application should be postponed. I do note, however, that the company has indicated that it would not lodge any sanction approval until after the CA disposes of the appeal, but again, it is premature for me to go into that. Thus, the application for either stay of the convening of the scheme meeting or adjournment of the meeting is denied. So that's my decision this evening. Anything further, Mr. Chan?
Your Honor, just an order as to just on the question of costs, Your Honor, because
All right.
the costs I think should follow the event. I think the cost range, Your Honor, is between $3,000 to 11,000. So the midpoint is about 7,000. So I'm just asking for just above the halfway point at $8,000 here.
$8,000 all in?
All in, Your Honor.
All in. All right. Mr. Chu?
Your Honor, I will ask for no order as the cause. I mean, the reason why I'm asking for it is because my clients in filing the appeal and in this stay application is really doing it in the interest of all the creditors who will be affected by the proposed scheme. Your Honor, my client is a small creditor in the larger scheme of things, and having put in money to bring an appeal in the interest of all creditors, in the interest of transparency, I will ask Your Honor that there be no order as the cause, in accordance with Your Honor's usual practice of not ordering costs in relation to insolvency proceedings, Your Honor.
Mhm.
That's all I have, Your Honor.
All right. Thank you, Mr. Chan. Sorry.
No, Your Honor, I mean, in the practice, I can well understand in normal scheme hearings or like the convening meetings, etc., where parties put their particular view. But this is different, Your Honor. They chose to file a stay. And I think the normal consequences should be borne, because on one hand, they say, look, they're all the wasted costs, but when they incur the cost and they fill an application, they say, no, the other creditors should be affected. So as a matter of principle, Your Honor, this is different from normal hearings where creditors appear, make reasonable arguments at the convening or sanction stage. This is a separate application. Cost should follow the event. In fact, they should follow the very same principle. They're concerned that the company is losing the cash. So, Your Honor, I maintain that there should be an order for cost and we submit 8,000.
All right. I do think the cost should follow the event, but I will fix the quantum at $4,000 all in.
Grateful, Your Honor.
$4,000 all in to the company. All right. Anything else, Mr. Chan?
No, Your Honor.
All right. Mr. Chu, anything further?
Nothing from me.
All right. Thank you both. All right. All right. Thank you. I believe you'll have other matters to pursue, so I'll leave you to it. All right. Thank
Good
you.
day. Thank you.
Good day. Thank you.
Court is adjourned.
Mr. Chan, thank you.